Hello, my name is Kerry Stairs and I'm a partner specialising in environmental, social and governance, or ESG, at Charles Russell Speechlys. In this short video, I'm going to flag some of the key things that you need to know about the UK Government's 2025 statutory guidance for businesses complying with the Modern Slavery Act 2015. The UK Modern Slavery Act has been around for 10 years. Section 54 requires any organisation doing business in the UK with a consolidated global turnover above 36 million to publish a modern slavery statement. The statement needs to set out the steps a business has taken to ensure that slavery and human trafficking are not taking place in any part of its business or supply chains, or to state that no such steps have been taken. The statement must be approved by the board, signed by a director, and published on the company's website. The new statutory guidance released in March 2025 clarifies how businesses should comply with Section 54. It sets out the government's expectations for the content and quality of modern slavery statements and provides practical advice on what disclosures should look like under each of the reporting headings listed in Section 54, namely the company's structure, business and supply chains, its policies in relation to modern slavery, its due diligence processes in relation to modern slavery, its assessment and management of the risks of modern slavery, and the effectiveness of its due diligence processes and modern slavery risk management. And last but not least, relevant staff training. Although the guidance is primarily aimed at companies within the scope of the Act, it also strongly encourages smaller businesses to produce a statement. 5 headline points that I want you to keep in mind. First, the guidance does not reinvent the wheel. It aligns with globally recognised best practice frameworks for businesses carrying out human rights due diligence, including the UN Guiding Principles on Business and Human Rights, or UNGPs. And it strongly encourages companies to adopt these frameworks for carrying out due diligence across the full spectrum of human rights, not limited to modern slavery. Headline point number 2. Companies are expected to find and disclose real risks and incidents of modern slavery. The guidance says expressly that companies that carry out meaningful and thorough human rights due diligence will find instances of modern slavery, and it warns that Section 54 statements that disclose no risks or incidents are likely to be inadequate. Third, the goal is not zero risk, it's continuous improvement. Companies are expected to continuously improve their response to modern slavery, with the guidance categorising disclosures as either Level 1, good practice, or Level 2, best practice. And as companies become more familiar with their reporting requirements, they should progress year on year to include more Level 2 disclosures and beyond. Fourth, collaboration is key. Alignment with the new guidance requires companies to engage with internal and external stakeholders, including direct and indirect suppliers, NGOs, and trade unions. Companies at the top tier of a supply chain should minimise the demands of due diligence on those lower down the chain with less capacity and leverage by doing what they can to streamline any requests for data and assuming a fair share of the costs involved. Fifth and finally, beware of over-reliance on audits. The guidance stresses that while audits can be a useful tool, they are unreliable and should not be the only tool used by companies. They are expected to supplement audits by engaging with workers and workers' associations. So why does the guidance matter? Why does aligning with it matter if there's been no change of law? Well, first, the guidance reminds companies within the scope of Section 54 that if they fail to produce a modern slavery statement, the Secretary of State may seek a High Court injunction. Failure to comply with an injunction can result in contempt of court and an unlimited fine. Thinking beyond compliance, however, and more strategically, the government has signalled its intention to reform the Modern Slavery Act, aiming to strengthen the UK's approach and bring due diligence and disclosure requirements in line with international best practice. So taking steps now to understand and align with this guidance is therefore a savvy move and will future-proof your business against future regulatory change. Moreover, investors, lenders and large corporate customers are already assessing alignment with the guidance, and we are seeing some large companies starting to expect Tier 2 best practice disclosures as a condition of doing business. And of course, companies with a valuable brand that talk very publicly about having a positive social impact should pay particular attention, as failing to align with the guidance may lay them open to allegations of social washing. For help understanding and aligning your policies, processes and disclosures with the new guidance, or advice on any related issues, please do get in touch with me or your usual Charles Russell Speechlys contact.